Hey authors, you know that one of the most frustrating things in the industry is having your books pirated, and one of the most important things is to send those takedown notices to make those pirating sites take down your books that are up there illegally. So what do we need to know about takedown notices? Today, let's talk to everybody's favorite IP and entertainment lawyer, Tony.
Hi, my name is Tony Iliakostas. I'm an adjunct professor of entertainment law and IP at New York Law School, and I have an Instagram, TikTok, and YouTube account called The IP Professor that is dedicated to all things intellectual property.
One of the biggest things that we deal with in the author industry is having our books taken and then pirated on other sites for people to download illegally. This costs thousands and thousands of dollars for the publishing industry every single year. And one of the only solutions that we have to this right now is submitting takedown notices to take these pirate sites to the point where they actually have to take down our illegal copies of our books. And that's how we're protecting ourselves. Tony, I want you to break down the process and what documentation we need to do this to make sure that as authors and publishers, we are protecting ourselves at least a little bit against this piracy.
Absolutely. So first things first, let's get it out of the way. Piracy is also called infringement. Infringement is a no-no in every aspect of IP, but certainly in copyright law. And I know that we've talked about the definition of copyright before when, it's original work of authorship fixed in a tangible medium of expression. When you make a copyrighted work, you automatically become the copyright owner, but you cement that with copyright registration in the U.S. Copyright Office. Okay, fantastic. Now, the next step is understanding that as a copyright owner, you have rights that are asserted to you as a copyright owner. You have the right to publicly display that work. You have the right to publicly perform it. You have the right to have certain derivative works out of that. There are 6 rights that are afforded to copyright owners under the Copyright Act. If any other person other than you sort of exhibited those rights, they created derivative works out of your copyrighted work. They publicly performed your work based on your copyrighted work. If anybody else but you did that, they're violating one of the exclusive rights afforded to you under Copyright Act 17 USC 106. So plain and simple, when you see piracy taking place on platforms like ZLibrary, which from what I understand was recently in a massive DMCA takedown situation, that is a classic case of where rights are being infringed on by other copyright owners. So for any authors out there who have had their works, if their works were the subject of some type of infringement, it's a pretty standard process, but step number 1 is to ensure that your work is registered in the U.S. Copyright Office. And the reason why I say that is because normally with DMCA takedown notices, you want to show that you are truly the copyright owner. But let's say that even after a DMCA takedown, the matter doesn't stop. You can escalate it to federal court and file a copyright infringement lawsuit, or actually, better yet, the Copyright Office has just rolled out the Copyright Claims Board, which is kind of like the small claims court version for copyright cases. You can bring up to 2 claims valuing up to $15,000 each. And it's a bit more cost-effective measure and even a more efficient, quicker way of getting a remedy, as opposed to going to federal court, buying an index number, waiting it out with discovery and all that jazz. So copyright registration, I think, is step number 1. Then step number 2 is to go onto the platform where your work is being infringed on, and either finding through like an FAQ page or a help us page somewhere, something about contacting the webmaster for a DMCA takedown. And basically it may typically be a form on the website, or it may be an email alias, but laying out all the facts. I'm the copyright owner. This is the copyright registration that I have in the U.S. Copyright Office. My work is being infringed on. This is an unauthorized use of my copyrighted work. It violates one of these rights under 17 USC 106, and you can enumerate it, and you can ask for the webmaster to take down the work that's being pirated. One thing I would mention is that the premise of the DMCA is to not shift liability on the websites that are hosting these platforms. It's actually to shift liability on the person who is using that platform to upload that content in a pirated fashion. So the perfect example is, think of after Sunday night football, or after Sunday, all the football game highlights, or maybe like an extended cut of a football game, is posted on YouTube. Mm-hmm. And let's say the NFL identifies these clips on YouTube that were is in every sense of the word, an unauthorized use or dissemination of NFL football games. Instead of individually suing YouTube for copyright infringement, what they do is they work with YouTube to issue DMCA takedown notices against the channels that uploaded those NFL highlights. So the liability now is on those individual users. They get DMCA takedown notices, they get marks on their account, and if they continuously violate it, that could be grounds for an account suspension, maybe even a ban of their account on those platforms, and that would be laid out in the terms of use and service of those respective websites. So I think it's important for authors to know that the premise of the DMCA is not to actually put liability on the websites that are hosting that pirated content. It's to shift liability on the individual user who is the one uploading that content. The DMCA has, was created as a result of litigation surrounding that question. Who is responsible for uploading infringed on content? Is it the website or is it the person uploading that content? So that I think is kind of important to stress there. But bottom line is, after you've done that DMCA takedown form or email correspondence and you've laid out all the facts, then it's really up to the website to do their part. The ball's in their court to issue the takedown notice, to comply with the request, and then kind of the rest is history. But if in any part of the process you have questions about how to properly draft the request to these websites to take down this notice and to reference all this legal mumbo jumbo, working with an attorney is going to be very helpful. So that way you're saying everything you need to say about enforcing your copyrighted rights and just putting the ball in the website's court to make sure that they do their part to take down the pirated material.
And I'm sure when cases are escalated and have to be taken to court, making sure that you have that lawyer looking over things will actually help you in the long run, because if you do something and miss parts of it, that could end badly, right?
Yeah, it absolutely can. I mean, it's just a good question or case study rather of due diligence and just dotting your I's, crossing your T's. You don't want any glitches in this process. It's if you see that your content is being infringed on and it's your copyrighted material, it's a very easy process now to go ahead and just take down that material once and for all. Case law has really helped illustrate this point of just a matter of one party doing their part in properly enforcing their rights led to the outcome that they sought and desired. So I think that that's something that bears a lot of relevance for a lot of authors here. And certainly, exercising that due diligence, working with the attorney, having that language laid out in a very clear fashion for these websites so that they know that you mean business and you're not just, hiding behind this like facade or something. It's going to make a world's difference for sure.
Now, when it comes to submitting these takedown notices, is there very specific language that we need to include, or is that going to vary a little bit depending on which lawyer we work with?
It's going to vary on the lawyer, but I would also say it's going to even vary on the website. And I'm not going to use, I'm actually not even going to use book platforms for this example. I'm actually going to use Zazzle or like these print-on-demand websites. Once upon a time when I was working with the Albert Einstein estate in my previous employer, we had to frequently issue DMCA takedown notices of the use of what we deemed were violations of Einstein's name, image, and likeness being used in an inappropriate fashion. We also, on behalf of merchandisers that we worked with who created designs of Einstein t-shirts, we found that their designs that we had worked with other designers were on these platforms, but on a print-on-demand platform. So there was like one design that we worked with of Einstein where it was like Einstein in black and white. He's sitting in his chair, and in the background, it's like this blue and green galaxy, kind of like trippy psychedelic looking design. So it was an ingenious design that our merchandiser licensee that we worked with had commissioned by way of a license agreement that we worked out between the Einstein estate and this merchandiser. Well, that design was found in a bevy of different websites: Zazzle, Etsy, Teespring, Redbubble, a bunch of different print-on-demand websites. The process was very tedious, but essentially I had to go to each link that I found an infringement of a design or what I deemed an infringement of Einstein's name, image, and likeness. And I had to copy the URL, put it in a spreadsheet, identify the ID number, also put that in the spreadsheet, and also provide the item description and put that in the spreadsheet. And sometimes pictures were required as well. So that was Redbubble's demands. With Teespring, it wasn't that case. All I had to do was provide just the URLs. Still, again, very tedious, but it wasn't as exhaustive as what Redbubble required.
Mm-hmm.
So I'm using that as an example because some websites may have different demands, but I think what is going to be uniform is proof that you are the copyright owner. That you, if you can show that proof, a copyright registration certificate or the registration number, maybe you can even link it to the public catalog that is available on the Library of Congress website with your registration. Showing that proof that you're the copyright owner is going to help streamline that process. And like I said, working with an attorney to help lay out what language you need to include is going to be vital. Odds are that you're going to want to include language that says something like, this user has uploaded my copyrighted material in an unlawful manner that violates 17 USC 106, subsection whatever, and you can lay out what exclusive right under copyright law is being violated. Is it the public display right? Is it the derivative work right? It could be a number of different ones that are applicable depending on what the copyrighted material in question is. So all that detail, and don't mince that those details either. I know that less is more, and I to some extent that's true, but I think in something like this, try to be as exhaustive as you can, because the more information you can provide that you are the copyright owner, the easier and maybe even the quicker it's going to be for that takedown notice to be issued.
And we do like to make sure that we're doing things at a quick pace, which is why it's always helpful to hand it off to a lawyer who knows exactly what they're doing so that we don't mess up in the process. If you have questions on making sure that your books are safe from these piracy sites, go ahead and drop them down below. We'll be monitoring this over the next couple of days and weeks. And if you want to reach out to Tony with further questions, you can always find him online at
The IP Professor.
If you have questions on takedown notices or how to prevent your books from being pirated, drop those down below and hit that subscribe and notification bell, because every single day we're dropping techniques and tutorials to help you level up in both the writing and the reading world. And we're dropping those videos daily to help you navigate what you're doing to make it even easier so that you can thrive. I'll see you in the next episode.